This is one of those cases where everything changes in a matter of minutes. A defendant with no prior criminal history, a violent home invasion caught on video, and a judge who has already seen everything. What started as a plea for leniency is about to spiral into a brutal courtroom reality check. The defense is betting on sympathy, a rough childhood, no record, and a claim of not being the main aggressor. But here's the twist: the judge isn't buying it. And when video evidence enters the courtroom, words stop mattering. The real question is, can someone with no past still deserve the maximum punishment for one horrific night? Let's break it down.
All right, so I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
Thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence, but the one thing that I think needs to go in Mr. McGee's favor, obviously, is that he did take responsibility. He did plead. Obviously, he's gotten some bad legal information in the jail since we were last here in court. But that shouldn't change the fact that Mr. McGee has had no criminal history other than some traffic citations and a few failures to appear on those traffic citations before this. He's never been in our system. He's never been on probation before. Never been sentenced to prison before because he has no criminal history. Mr. McGee did not live the same life that many of us have lived. One of the letters that I received from a close friend, they've known Devin since 2017, so approximately 6 years. Not only did they speak very highly about how Devin would typically put himself before others, and he had a very rough childhood, his mother passed away in front of him at the age of 27. They had no father figure. They were tossed and moved around with their 3 aunts from 2007 to 2017. They both suffered physical, mental, and verbal abuse from 2 of their aunts. Mr. McGee also has a 3-year-old child. He's never really stood much of a chance. He's never had a positive male figure in his life. And that's not my words. Those are the words of close friends and family members that have kind of written on his behalf. They were completely shocked and said that this was out of character for him to partake in this crime. They believed that he was following his brother. They said that this is not who Devin is. Obviously, the court has just what it has in front of them, which is the evidence from that case. And if you just look at the evidence in that case, obviously it's going to give you pause because of the nature of, and the violence that took place in the offense. While my client understands the law of parties and he knows that he's just as responsible for whatever his brother did that day, I will say that he was not the aggressor or the main aggressor in the situation. The crime that they committed was despicable, and he would agree with that. He thought that he was going over there to retrieve stolen property. He did not know that his brother was going to start shooting. And in visiting with Mr. McGee, I believe he was also a little afraid and didn't know what to do in the situation once it started going further and beyond what he thought it was going to be. Further, Mr. McGee has told me that he has found religion. He has one of his write-ups has been because they did not warn the jailer when they were going to pray. So that was one of the write-ups that he had. He also had a jumper malfunction with his buttons. But he says that his newfound religion has given him discipline and peace in his life. He has a son now. He apparently did not know about that. I believe he became aware of that while he was incarcerated. The child is 3 years old. And he would like to have some sort of a life with a son. I would suggest that he get 10 years deferred adjudication probation, and if he messes up even 1 iota, he's got the full range to deal with. So I would suggest that he get 10 years deferred probation, be put on intensive supervision, 0 tolerance, and actually be given a chance, because based on his criminal history, this is not who he is. This is not, and I hope the court doesn't take into account the fact that he tried to withdraw his plea today. I think he got some bad information.
No, I'm not worried about that.
Yeah, he got some bad information in the jail, but he is eligible for probation. I would ask that he get probation, and I'd give Mr. McGee a chance to address the court and explain why he should get probation.
First and foremost, I would like to apologize to the victim in my case. I didn't know, like my lawyer said, I didn't know that my brother was going to Go over and see. He told me.
Hang on a second, Devin. Just stop. All right. Y'all went over there with a gun. Hang on. I've watched the video, and you were the one who egged your brother on the entire time. I'm not even sure that your brother would have done what he did had you not been there, just in his face. Do it, do it, do it. I've seen it. Hang on. I've seen it. There's probably nothing you can say right now that's going to help anything, because all you're doing is trying to not take responsibility instead of taking responsibility. Ms. Malfino.
Thank you, Judge. You just took the words right out of my mouth.
Sorry.
We're having no criminal history. We saw him go from 0 to 100 in a matter of 2 hours. On behalf of the Jones family, we appreciate the court taking the time when we addressed Tevin's case to carefully consider all of that evidence. This is a unique situation where I don't even feel like I need to argue the PSI. You have everything in front of you. I know you recall it. I know you remember it. I know you know the violence there, and he was responsible for those actions. He needs to be held responsible. I appreciate Mr. Nick's argument. I respect him immensely as a professional. He's just doing his job. The words probation are just absolutely ludicrous for this case. I think Jason said it best when he told you this is not a gift to Devin. This is a gift to them, to let this be over, to stop the nightmare. They deserve to have some peace from this. Your brother's gone for the rest of his life. You better be glad that your exposure is 30 years, and that's not a gift to you. That's by the graciousness of this family. Judge, on their behalf, I would respectfully ask 30 years.
This is where the entire defense strategy completely collapses. Up until now, the argument was built on sympathy, no criminal history, a troubled upbringing, and the idea that he was just following his brother. But the judge introduces something far more powerful than words: video evidence. And in criminal cases, video doesn't just suggest, it confirms. Notice how quickly the tone shifts. The judge isn't debating anymore, he's asserting. That line, "I know what I saw," is critical. It signals that the court has already formed a clear picture of intent and participation. And here's the legal reality. Even if he didn't pull the trigger, under the law of parties, he's just as responsible. So let me ask you, should someone face decades in prison even if they weren't the one firing the weapon but clearly encouraged it?
Judge, on their behalf, I would respectfully ask 30 years within the firm of the devil.
Can I present the 2 letters?
So, I appreciate Mr. Nick's argument. I appreciate these letters. The problem with these letters is I don't know. I wish if they hadn't seen that the people who are saying what a good person you are and how much remorse you supposedly have, and that you've taken responsibility, saw the video of what happened that night. There's not a whole lot of times here in court that with cases we have the opportunity to have pretty much every single part of an offense on video, right? And that makes this unique. It's unfortunate probably in some cases that we don't, because probably other people who've done similar things get maybe some breaks that they shouldn't, because we don't have all of that. What you and your brother put that family through that night is the stuff, and I think I've said this before, the family's probably heard me, I know, tell your brother this. This is the stuff out of a movie. This is what makes people have nightmares at night. And you instigated it. You walked with your brother with that assault gun, however far y'all had to walk, knowing you weren't just going to get property holding a gun. Well, you can object whatever you want, but I know what I saw. I know that you instigated him to keep doing it. You showed him how to take the safety off the gun. I remember all of that. So at this time, I'm going to find that you entered a plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of burglary of a habitation with intent to commit aggravated assault. I'm going to sentence you to a term of 30 years in the institutional division of the Texas Department of Corrections. Clear the table so he can have a seat where they're going to do a victim impact statement.
Devin McGee, October the 8th, 2021 is a date that me, my family will never forget. You and your brother attempted to kill my husband, Jason. You and your brother tried to kill our innocent little dog as you entered our house. Prior to entering the home, the same very home that Jason and I built for our family, that we raised our family in, raised our children in, and it also became the home of our grandson. Your nephew, you both taunted us for what felt like a lifetime. I will never forget the sounds of bullets spraying through our home. I will never forget the visual of seeing my love, my soulmate, my husband, the father of my children, the grandfather of my grandchildren, slumped down in a bathtub filled with blood, glass shattered everywhere. The sight of spent casings and shattered glass, spent casings that kept being discovered long after the crime was committed. You two had one goal in mind that night, and you both know that is correct. The goal that you both had was to kill every one of us in the home that night. And I'm here to tell you, look at me. I'm here to tell you failed. You are worthless. We have a very small fraction of our many supporters that are here today to see justice through, that we're here to see justice through on your brother as well. Our lives are forever changed. They'll never be the same. But one thing that we can take pride in and knowing and going forward in is that justice is served. Justice is never fully served to the victims, as this is something that we have to go forward with ourselves and deal with on our own behalf. There's nothing that no one can fix.
And just like that, 30 years. This case is a powerful example of how quickly a life can change when a situation escalates into violence. The defense leaned heavily on background character and second chances, but the court focused on something far more concrete: actions, intent, and impact. The presence of full video evidence removed doubt, and the judge made it clear: encouragement and participation carry just as much weight as pulling the trigger. The victim's statement that follows only reinforces the emotional and psychological damage left behind, something no sentence can truly undo. In the end, this wasn't just about punishment, it was about accountability and closure for the victims. Now, I want to hear from you. Do you think 30 years was justified, or should the court have considered probation? Yet, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.